Okay, so now it's great to be here today. I'm honored to be the first speaker of the day on an important topic, I think, and I'm also very happy with the two speakers who will speak after me. And I really think that the papers are connected. They all are very close to each other, I believe. We will see. And I'm also very happy with the introduction of Wayne, because he helped me to see what contribution I can make. So the title of my presentation is, why do we need the legal dimension anyway? So there is a sort of idea sometimes that the law is not that important and that we can use ethical policies easier and more effectively. For example, even the Dutch policy that is in use currently is based on an ethical approach and not on a legal approach, whereas in practice, the reasoning of the committee, the commission, colonial collections, is quite legal. So when I read the advisory reports, it is lawyer-like reasoning which you can find there, which I find highly interesting, because I believe that there is a push by the Commission to show that ethics is not meaningful in this context without a legal underpinning. So my main question today is, why do we need a legal dimension when addressing certain legacies of colonial injustice? And then, Wayne already mentioned this, normally the law is used to keep the past in the past. So injustices that happens a long time ago are usually left alone by the law. They do not consider them anymore. There are statutes of limitation. So that is the normal situation. But sometimes, in some instances, we need to question this legal normality and imagine the legal dimension differently. There can be cases of injustice that they are of a certain type that demands legal redress anyways. So then we have to break through this idea of the law as a protection of the past. So that is what I want to talk about. When is there a moment in which we need to question the legal normality of leaving the past alone? And then I will conclude that there is such a moment in the debates in which we take part, around colonial collections, for example, that law's role is important, that we cannot escape this legal dimension, that we need to use it, that we need to address it, but that we should also be aware of its limitations. So law cannot do everything. It is an important part of what we aim, of what we should wish for. But we also need ethics. But we need both. We need law and ethics, but we cannot do it with ethics alone. So ethics without law is very fragile, is my idea. So if you use the legal dimension in a good way, which is hard, then you can solidify the ethical policies that we always need. So that is in a nutshell the abstract. Then I have even an agenda, because I had plenty of time. So I have even an agenda. So I start with the kings. So I was a bit inspired by the documentary Dahomey. I hope you've seen it already. If not, you should go there immediately. It is about kings in boxes, as one of the in one of the reviews it was mentioned like that. So I will start with the exile of the kings. And why I'm starting there, because I will talk today only about one category, the so-called objects taken during the punitive expeditions, so war booty, just warlike situations in the colonial past, sometimes understood as the clearest examples of colonial injustice with regard to the looting of objects. And I start there because there is a sort of common opinion that you say, well, this injustice is so visible, so tangible, that we should undo those injustices anyway, that we should start there somehow. And there, the question of the legal is interesting because there may be also support for a legal redress in those cases. I will come back to that. Then I will revisit the Saar-Serval report, which I still think is a very important text, a sort of classic text already in our project as well, and see what they recommend. Then I will go back to legal philosophy and show if there is an argument in which you can say even if the law at the time allowed for certain looting of colonial objects, then there should be a possibility to disqualify the legal character of that legitimacy. And I think there is such an argument, so I will point to that argument. And then I will end with showing the advantage of a legal approach compared to an ethical approach only. So I will show why the law can help to prevent certain ways of doing that are not particularly helpful if you are really aim for redress and restitutionary work. Okay, we start with some pictures. So the review of the documentary of the Home in de Groene Amsterdammer was called Kings in Wooden Boxes. And I like that title a lot because the statues that were restituted a few years ago from France to Benin are called kings. So they are, and there is a reason that is fitting. If you have seen the documentary, it starts with lots of time is spent in the French museum, the Quai Branly, of the way the objects, the statues, are put in the boxes, very carefully, with great respect. You can say it's clinical, but it is also respectfully done, I would say, as if they are ancestral remains, almost. So there is also here there is not a real distinction anymore in the documentary between the statues and, for example, ancestral remains in terms of the care for the objects and the way they are put in the boxes. And the return of the kings is, of course, where the documentary is about, and the second part of the documentary, then you have this fantastic debate at the university in Benin among mostly young people, students, discussing the meaning of restitution, which is very, very good quality. I even thought, if we can have this quality in this room, we are doing a very good job. Well, okay, but the kings in boxes reminded me that in those military expeditions, which is the case I will deal with, there has been looting of objects, very important objects, royal objects, sacred objects, etc., objects of power, of political power, of religious power, etc. But the looting of the objects was only one thing that happened, one event, and the other event was the exile of the king, the living king. So, for example, in Dahomey, at the moment the objects were taken that have now been returned, also the king was exiled. The Dahomey king, the Béhanzin was his name, and he was exiled in Martinique. And there is a picture of the king with two of his wives in exile in Martinique. And the picture below are, of course, the three famous statues that now have been returned. And one of them, the man shark on the right side, symbolizes the king Béhanzin. And that is also indicated in the documentary. The documentary doesn't say a lot about what really happened, but this is clear. So there is a correspondence even in the pictures, if you can see. So I was somehow struck by the arm of the woman and the arm of the statue here. So there is some correspondence, and I think we should keep in mind this correspondence because these two exiles are, of course, not only synchronic, but also very closely connected. And there are many more examples. For example, this happened in what I think present Ghana. This is the Ashanti king who is put in exile. This is 2 years later. He is in exile. I'm not exactly sure where. I thought in the Seychelles. Yes. And the objects that were taken at the time included this umbrella finial, or umbrella holder, made of wood covered with gold, which is currently in the British Museum. And if you look it up on their website, it is under the category contested object, contested collections. And this was probably taken during this moment of the exile of this king, and also related to the king, to this king, to Asantehene Prempeh I. And here also there is a correspondence because the umbrella in the picture somehow reminds you of this umbrella holder that was looted at the same time. And both exiles are interrelated, of course. And we should keep that in mind to understand what happened. It was not only about looting, but it was about something else. It was about a double exile and taking away of dignity at the level of the king, but also at the level of the regalia, the objects that signify royal power, for example. So then there's the very famous one, of course, 1897, Benin City. Now the pictures you know, but also there was the exile of the Oba, Ovon Ramwen Nogbais, and he was exiled to Calabar with 2 of his wives. I will not go into this because you know this case, of course, but also here I found it striking that there seemed to be a sort of correspondence in the pictures in the way the people are posing somehow. There is a sort of relation. You can see that these pictures somehow belong together. It's very tragic, of course. And what I also like of the pictures of the kings in exile, that they are all seeming or able to keep their dignity somehow. They are still dignified, even if they are living under very debilitating and humiliating circumstances. So there is a pattern that we see here. There is the exile of the kings. There is the forced exile of thousands of artifacts in each case from the courts and the royal palaces. The artifacts, of course, are sold and redistributed over museums and private collections. There is this violent historical context, the scramble for Africa in these cases. They are all examples of so-called punitive expeditions or colonial wars, which were part of bigger economic military strategies. And the subjugated kings and peoples were, in the context of these events, routinely portrayed as subhumans and savage beasts, because you can also show that in the public opinion at the time in the European countries involved. But it is not only an African story, it is also very much an Asian story. So one of the projects we are doing, I think the NIOD project about the Bantan destruction, includes also the exile of the Sultan of Fajiri, is doing that one. But this is in Sri Lanka, in 1815, the British had taken over Sri Lanka. They were the new colonial power. And the king at the time, Sir, what was his name? Vikramaraya Singha, was exiled by the British. And there is a book about this last king, a recent book by the Sri Lankan anthropologist Kananath Obeyesekere, a beautiful book, I would say. And he describes this the life of this last king, and also tries to restore some of dignity to him. He doesn't want to glorify him, but he wants to show that he wants to show his respect for this king, which was very much portrayed in a very bad light by the British, because the British didn't took over the kingdom of Kandy by force, but by intelligence. So at the time there was a British so-called master spy, John Doyley, who for years organized an intelligence network into the kingdom, and by betrayal and corruption, etc., he was able to conquer the kingdom and made the king flee and put him into exile. And during his voyage into exile, into India, the king was on a ship for several weeks, and during these weeks he was had mood swings, and Obeyesekere describes him as cabined, crypt, confined, and he quotes Shakespeare by saying that. And I think that is a very nice way to put it, because it is really the king in the box again. So the king is put in a box, just like the objects are also at the same time simultaneously, as described by Obeyesekere, catalogued, accounted for, and deposited in London for auction. So this is a double exile. But we are also in the Netherlands. This is the last example, because otherwise you think, what is he doing? We are talking about the Netherlands, of course, and in Sri Lanka there was also, and Wayne already mentioned it, objects have been restituted to Sri Lanka recently from the Rijksmuseum. Among them, most famously, the cannon of Kandy. And the looting of these objects took place in the Dutch colonial period in Sri Lanka in the 18th century, in 1765. And in 1765, there was a war against the kingdom of Kandy again, and this war was waged from the Dutch side by the governor Van Eck, and it was sort of successful. It was not so nicely done as the British would do a few decades later, but still the king was put on flight. The army made the king flee away, and many objects have been looted in a very irregular and brutal way. And among those objects was the cannon and other objects which were sent to the Netherlands. And some of the objects have been returned immediately. But what's interesting is that presently in Sri Lanka, and I happened to be there a few weeks ago for another project, you still have much monuments from the VOC time, among them the Wolvendal Church, which is in need of restoration, as you can see. But still, within the church, you find the tombstones of the Dutch governors. And one of the tombstones is the tombstone of Van Eck, so the governor of the cannon, so to say. And his text on his tombstone is very interesting, and it is very difficult to read. It is in Dutch, so I have translated it for you. It says, first who he is, etc., and when he lived, and then there is this detail which I will read aloud. Having in person, so here rests Governor Van Eck, etc., having in person captured, just before he died, the almost inaccessible and by nature invincible invincible kingdom of Kandy with its capital on behalf of the VOC and put its king to flight. So there is a sort of glorifying of his role in the capturing of the Kandy kingdom, its capital, but also making the king flee. So to put that on your tombstone is a bit arrogant, I would say, at least remarkable, because there are not that many tombstones on which you see a sort of CV-like mentioning like this. But there is also something about a humiliating element. I am the one who made the king flee. Whereas in all the histories of the Dutch in Sri Lanka is mentioned how humiliating the Dutch, the humiliating experience of the Dutch, because they had to kneel before the king of Kandy. So they had relations with the Kandy kingdom, which remained a sort of independent kingdom in the middle of the island for the whole period. And whenever they went to the king, they had to kneel, which they found very humiliating. And this is a sort of revenge, I think, for this kind of humiliation. It is meant to say, we are superior than the king. I am superior to the king of Kandy, and I'm proud that I made the king flee. Now, this king did not. I think the kingdom was re-established shortly afterwards, so it is a bit strange, but it's still very, I think, important to keep in mind that making the king flee was considered highly important and valuable, even so important that it should be mentioned on a tombstone. Okay, and then there is something else. So I was recently in another panel with Wayne, and there was also one of the speakers was Maxine Pally de Jong, a playwright, and she made a piece on roof, looted, and there's one sentence she performed, which I think is relevant, and she said, the strange thing about being stolen is that it is a violent event that needs to be done very carefully. So this violence with care for the king, who needs to be put in exile, and but also care for the objects, because you want to take over the kingdom in a violent way, but you want also to profit from it by taking the objects. So this careful aspect of looting, of the exile of kings and objects, is something to keep in mind, because that also say that you need a lot of preparation for such an operation. So it is done with purpose. You cannot do that spontaneously. You must prepare. So, summarizing, the exile of the artifacts mirrors the exile of the kings. Both synchronic instances of exile, captivity, consist of violent acts that must be prepared and carried out with great care. Both synchronic instances of exile effectuate the long voyage into homelessness, the irreparable loss of one's world. So the consequence is homelessness of the king, but also of the objects. And we should be aware of the collective humiliation involved in these calculated and interrelated double acts. They are meant to subjugate communities by depriving them, in whole or in part, of their dignity, of their culture, customs, and values. And perhaps you can say that it is the purpose is to diminish them. Perhaps they can, some of the culture can remain, or the king, a new king can take it over, but in a diminished position, in a subjugated or inferior position. And this is a quote I used more often from Professor Followin Shalom from 2009, which captures all these ideas. The refusal to return such cultural objects is tantamount to keeping a people's history and heritage in captivity. and there is no doubt that the colonial powers knew the import and the devastating effect of the removal of irreplaceable cultural heritage. So now I'm heading to the legal part. So what to make of this, given that this was not a looting such as an ordinary theft, but something else? There is much more involved in what the purpose of these events was. We need other words, so we cannot use loot so easily. Looting does not capture what is really going on, in my opinion. The word is not completely fitting. And I like the concept of dignity takings, and also I've mentioned it before in earlier presentations, but also here I still think it is valuable. And the concept is developed by Bernadette Atouahine, an American scholar with Ghanese roots. And she says that dignity takings are property confiscation that involves the dehumanization or infantilization of the dispossessed. And I think the examples I gave, which is a pattern, it is not one single event, but it's a pattern of events, and I only gave a few examples of this pattern, is a typical example of what dignity takings are. So the whole purpose is not to have some artifacts. The purpose is to take away dignity, and then you can have the artifacts and profit from them, etc. But the first idea, the purpose of it all, is to take away dignity, to subjugate people for your own goals, economically, etc. And then there is, because we are talking about injustices that are extreme, there is this idea of irreparability, which is very strong in all these events. But at the same time, we should keep in mind that there is a sort of continuing dignity that is never lost. So that is also what I like with the documentary. The kings are still there in the objects and they can be returned, and that has a positive effect. So something can be restored. You cannot repair the past, but you can return the kings, and the dignity of the kings is somehow never completely gone. It's still within the object. I think that is a very important thing also to keep in mind. Okay. And then if you look at the Sar and Sava report, you see that they highlight this kind of injustices that I just mentioned. So the first thing they recommend is the restitution in a swift and thorough manner without any supplementary research regarding their provenance or origins. I also like that, so that you say the provenance research should not be too extensive. We should only do provenance research as long as it is really useful. Of any objects taken by force or presumed to be acquired through inequitable conditions, A, through military aggressions, B, by way of military personnel or active administrators, C, through scientific expeditions, and that's it. So the focus is very much on these very clear instances of military violent looting. And then restitution is more or less the only option that they offer. And they put it in a quite of a legal way. They say this must be done. But it is not explicitly legal what they are doing. It's still an ethical report. And they are talking about relational ethics, for example. But in their language, they are almost lawyers, especially in their recommendations, which I also think is very interesting because they intuitively understand that we need law and legal language in order to solve these kind of injustices. For example, of such a more of legal kind of reasoning in an ethical report, it's our recommendation to respond favorably and grant restitutions concerning objects seized within the military context described above, in spite of the specific juridical statute concerning military trophies obtained, etc. Very legal text. So they say restitution should be done even if the taking of object was legal at the time. That is what they are saying here. Even if it was, according to the colonial legal system, legal that objects were taken as war booty before 1899, even then restitution should occur. Yes. So here we touch upon the legality at the time. And Wayne already mentioned it. This argument is used a lot even today, especially by the British, but not only by the British. But the most famous statement is from Tony Blair, who said, relating to the slave trade in November 2006, and I like it very much because it's kind of funny. It's hard to believe that what would now be a crime against humanity was legal at the time. So he says, now we say it is a crime against humanity, and it's very hard to believe, but it was legal at the time, and that means we do not need to do anything about it, because it was legal at the time. And Sarr and Savas say, well, even if it's legal at the time, we should nevertheless restitute the objects. So then you need to disqualify the law at the time. You should do something with this law at the time. You should legally declare it invalid in order to supersede the law at the time. But that is not what really happens in the Sarr and Savas report, and it doesn't happen either in the Gonsalves report, because they say, because it was unjust, ethically unjust what happened, we should restitute the objects. But they do not really address the legality at the time. They just circumvent the issue somehow. And that is exactly where, for me, the philosophical problem is. Should restitution policies be merely based on ethical considerations, somehow ignoring or circumventing the issue of the validity of the law at the time? Or does one need a legal basis disqualifying or superseding the law at the time explicitly? If there was any, if it was legal at the time, which you should look upon, because it is not always legal at the time. It depends on your perspective. Perhaps from which perspective was it legal at the time? Only from the colonial perspective? And what about indigenous legal perspective? So we should look at that very closely as well, which does not happen that often. But even if it was legal at the time, then we should ask ourselves, don't we need a legal basis in which we disqualify explicitly the law at the time in order to have a proper basis to organize restitutions in a structural way? And there is a legal philosophy that supports a disqualifying of extremely unjust laws in the past. And the philosopher I only want to highlight very briefly because I'm running out of time. Gustav Radbruch has the famous formula which he made after the Second World War under the impression of Nazi laws, and he said, the conflict between justice and legal certainty is the law at the time, may be resolved in this way. The positive law, secured by legislation and power, takes precedence, even when its content is unjust and inexpedient, unless the conflict between statute and justice reaches such an intolerable degree that the statute as lawless law must yield to justice. So normally unjust laws remain law in the past. It's just a law at the time, unless we have to do with extreme injustice. And then there is a reason to prioritize justice and disqualify those laws, those statutes. So unjust legal norms can be law and will be law, will remain law normally, but there is a threshold. The legal character of a norm is forfeited only if the conflict between law and morality reaches a so-called intolerable degree, and dignity takings, so the instances I just dealt with, are examples of this threshold being exceeded, because we have then to do with property confiscation that involves dehumanization or infantilization. So that is I think, a strong example of such a form of extreme injustice that means that you can disqualify those laws, even if we are talking about statutes of a long time ago. So, and that is also where the documentary is about. These 26 is sort of coming back in the documentary all the time. But what is it? Is it an exception? Is it a miracle? Or is it a precedent? Is this what it is? Or is this part of a structural approach? Or is this just a miracle? And this uncertainty dominates the debate in Benin, in the documentary, which I think is very instructive. Because as long as we don't have a legal basis for what we are doing, this question remains in the air. Yes, because I'm running out of time. This is my last slide. Okay. And then one other, but this is really the end. Okay. Accepting a legal basis. These are the advantages to follow me in this reasoning, because when we have a legal basis for restitution, there are certain advantages. We can respond in a general, categorical way to this pattern of colonial injustice. We can say in all these instances, restitution must occur. Not only, it is not tokenism anymore, but it is a principled approach. It can become international law or international customary law. It is clear. In these cases, there is no legal discussion. Then you should return if people wanted to have it, etc. That is the first advantage. Second advantage, it abstracts from the meaning or value of the individual object. It is for me very important. It relieves the object of the responsibility to take care of its own restitution. And sometimes I have the impression that the object itself has to do the job. The object has to prove how important he is for the people to have it back. So the value of the object is going to dominate the debate, whereas for me that is not an issue. The issue should be whether the object has been looted in circumstances that it is about the loss of the object and the circumstances of the loss that should be the determining factor, not the importance of the object. So the value of the object is important, but not for the restitution. Okay, and then the third thing, the legal recognition of injustice means that you take accountability for the past, legal accountability. And that means that you are in a position that you become answerable for the past, liable. So you are below, and the claimant is high. He is in charge. So it is about the prevention of paternalism and the recalibrating of power relations. If you admit accountability, you are in a weaker position than if you say, well, I have developed an ethical policy and you can apply. So I think it's very important for a certain recalibration of the power relations involved that you should accept legal accountability. It changes something in the relationship, which I think is highly important. And then the last thing, and not the least, the restitution on a legal basis establishes the claimants in their position as legal subjects. So the formal equality of the claimants is emphasized. So you are taken seriously in a legal way. And it is a response to legal exclusion. So it is not only about the object being returned, but also being taken seriously as a full and equal legal subject, which was not the case under colonialism. So it is, and I think that is also a form of dignity restoration that should be a first step. And that also means that you are busy with repairing the law, the legal system itself, because you no longer profit from this legal exclusion, but you are repairing this exclusion which is still there. So this is more or less what I wanted to say. The legal recognition of and undoing of extreme injustice offers room for restitutionary work and dignity restoration and reinforces the agency of the dispossessed. It's only a beginning, a first step. It does not replace or substitute the ethical dimensions, but solidifies and supports them. I leave it here because I've totally run out of time. Thank you.
Yeah, it's always exciting. I just wanted to hold on to a few things. The idea of correspondence that you used, which is a concept that Tim Ingold is working with a lot right now. The question of temporal displacement, to displace it, it was a long time ago, is something else that you wanted to mention, which is interesting. And the question of irreparability, which we could come back to as a concept that David Scott has worked with, but also I cannot remember her name. And one of the lovely things is that care can also be killing, that to care one can kill the king, and what that might mean as well. One thing I want to challenge you with, though, is that for many people, especially formerly colonized people, legality or the law doesn't assure anything. So how do we deal with the fact that the law itself does not assure human possibility? And whether or not that is also historical, that the dehumanization that happened 400 or 500 years ago continues, so you can never be equal under the law, even when it is illegal and not unethical. So let's talk about that later, while we invite Krista Roth, Senior Lecturer in History of Art at the University of Glasgow, bringing law and ethics together in restitution's claims for sacred cultural objects. Thank you.
My presentation was there a minute ago, so I think it will return in due course. Meanwhile, I can maybe make a start and introduce myself, Krista, and from Scotland. So Scotland has its very own repatriation and restitution dynamic. The museums sector treats the question of repatriation and restitution very differently from London, and they are very engaged on these topics, especially museums like the Antiquarian, which is associated with the University of Glasgow. So it's a fine background against which to study these questions of care, killing with care, theories of competency and what it means to be obliged to achieve one's duties and obligations. So I'll be starting with just an observation about provenance and collections research, because this is my area of teaching, and then move to focus on the law and ethics. So law and ethics approaches in the context of three very well-known examples, which you will all know by heart. I will make two core arguments. The first in relation to common conceptions of the sacred, and the second with regards to the normative, and perhaps the bell will save me and I won't have to say too much about the normative. In any case, this is not a legal audience. And then in the conclusion, I am going to pull them all together. So the core arguments, the law, and the ethics. And I hope you will bear with me. So, colonial expansion was supposed to enhance the great economic power of European states, but it promoted collecting mania. Vast quantities of cultural objects were translocated from colonized territories to museums to be displayed as potent and symbols of loss and humiliation by the less powerful. They entered these collections readily and easily, but sending them back proves troublesome because of mummified thinking. I call it mummified thinking, and traditional ideas that collections need to be kept entire and whole in perpetuity. So we have these examples in 1753, British Museum Act, and we have many examples in Italy and France. Ethnographic collections comprise sacred as well as culturally sensitive material that are openly displayed, researched, trivialized, and neglected in Western institutions that present them as objets d'art. European powers recognized the principle of restitution of war booty after Napoleon's defeat, but restitution was completed only with respect to the European states, so the Ottoman Empire, African states, Indonesia, many others were not treated the same, and societies whose cultural heritage is being preserved are rightfully claiming their own belongings back. Now, faced with the special social question raised by cultural heritage looted and trafficked during the colonial era, disagreements arise over the issue of ownership and belonging and can often not be settled to everyone's satisfaction, as the legal philosophers would say. Disagreements are not just about legal norms, they're also very much about the semantic, the semiotic, and the conceptual. So semantic ploys aim for semiotic advantages and they protect blind spots. And conceptual disagreements occur at literally every level, including that of language. And the resulting fragmentation that results thrives on this obscurities of language. So fragmentation really befuddles restitution claims. At the material level, complex objects may be described differently if one alters one's perspective on the significance of the descriptions of their component features. In the museum world, there are many fragmented understandings of tangible and intangible systems of knowledge and practices that instill a curatorial reluctance to act on the obligations engendered by sacred material in their collections. Ethical considerations are tied to what museums consider their central role to be with regards to preservation and also preserving intangible cultural heritage. And the novel questions arising in respect of law's capacity to link sacred material incorporate both ethical and religious considerations. But when the domestic legal frameworks in question lack clear procedures and criteria for restitution, these questions become impossible to answer. So there's a dichotomous split, I would say, between law and ethics, and you see it very clearly in Britain, that promote polarized narratives and stale circular arguments. The non-compliance with moral standards puts a lot of pressure on justice, yet it is an inescapable byproduct of formalist legal arguments based on positivist notions of what the law is and what the law is supposed to do. Adjudicators often fail to identify objects as sacred cultural heritage to begin with, and we see this especially in cross-border normative conflicts. So confronted with the interplay between historical events and legal mechanisms, there are time bars, passing of time, the principle of legal temporality, all of those things that Professor Verhaert sketched out for us. And these arguments are readily invoked as reasons why the merits of transnational cases cannot be heard and orders of restitution cannot be issued. Adding to the complication is the uncoupling of the private and the public in subject specialisms that rely on the structure and the method of international law. And this intensifies fragmented thinking. So let me present the three paradigmatic examples that I've chosen. The cases, first of all, starting with the sacred frieze, and I'm glad this audience is not censuring me. Sometimes when I talk in Britain, I'm asked not to mention these marbles. So the sacred frieze of the Parthenon is a relief sculpted around the top of the interior colonnade. It used to be situated high up on the exterior wall of the inner chamber. It was part of the building program of the Acropolis temples initiated by Pericles. A total of 79 frieze panels out of the 111 survive, and they're dispersed throughout Europe, with the majority emplaced in the British Museum. Next up is the mummified monk, who trained his awareness on the next stage of existence. He lived and died during the Song dynasty, and his well-preserved encased remains were revered as the deity Zhangong Sushi in rituals in Fujian. But the ancient remains were reported stolen from the temple hall in Yangshun in December 1995, and Zhang Gong's current whereabouts are unknown. Following the rites of the Chan school of Buddhism, the medieval monk aspired to train to control the manner and the timing of his death, which is what he did. And a dealer bought the mummified monk then from a Dutch buyer after it was smuggled via Hong Kong into the Netherlands in the final years of Britain's 99-year lease, when Hong Kong was a British colony and had semi-autonomous status in China. The ensuing parallel international litigation link theft, trafficking, the sale of the mummified monk with trade colonialism, as well as the post-colonial illicit trafficking culture. Contemporary, sophisticated criminals find high-value antiquities simply irresistible. So the outcome of this litigation is significant because the Amsterdam court came to a finding that was wholly incongruent with the outcomes that were reached in 2 courts in China. So the power figures returned from France to Benin. They are up next. The return happened in 2021 in Mati Diop's celebrated film about the plunder of French troops from the royal palaces in Abomey in 1892. The main narrator is Gezo, is the mysterious protective Vodun figure of King Gezo, ruler of Dahomey. As the statue is being packed up in Paris and unpacked in Benin, the figure muses over his imprisonment in the Trocadero and the Quai Branly. Other scenes show zoomorphic figures of his heirs, including that of the last independent king of Dahomey and leader of the anti-colonial resistance. So what will maybe become clearer a bit later is that it's important to mention that Gezo staged a coup against his brother to become king. Each of them named their own sons crown prince. Gezo was at war also, so a lot of hostility around him. War with the Yoruba Empire over the profitable transatlantic slave trade. And when the British blockaded the ports to stop the trade, he became, or he reneged on some of the commitments he made in this regard. So, law and ethics, starting where we started with the Parthenon marbles, where the legal argument apparently, seemingly, favors London, but conflicts with the ethics argument, that favors Athens. The carved plaques of the frieze are important. They convey the genealogical history of Athens. Athena raises Erechtheus to be king, and with his wife, the couple consents to sacrifice their daughter to rescue Athens from Poseidon's son, who challenges his claim to the throne. So it's not widely recognized, but the final plaque, the central scene, is the dressing scene in which the family adorns the maiden with a funerary shroud. There's only really one scholar, and she's an American, who wrote a book in 2013 highlighting this very central, obvious, but hugely discounted interpretation of that plaque. So the Vatican collections are inalienable, much like the public collections of Italy and France, but the Vatican legal system allowed the Pope to override usual restrictions based on his ecclesiastical powers when returning 3 Parthenon fragments as an ecumenical gift to the Archbishop in Athens. The Pope declared that this gesture reiterated a truth, that if you steal something, you need to give it back, not just set your sights on the financial gains to be had from this theft. Now, museum practices are not always so aligned with ethical principles, but that is one instance where it was. Now, with regards to the complex material of the mummified monk and the encasement that his devotees made hundreds of years later for the protection of the remains, the Amsterdam ruling demonstrates a formalist approach that launders title, so it cleans that title and the proceeds of the criminal activity in commercial dealings. It's quite a complex case. The Chinese courts made a significant shift, however, on reclaiming the sacred associated with colonial era losses, in my view. They integrated progressive thinking with international public policy to formulate the basis for a restitution order. So this example shows that the law is needed to settle the ownership disputes, but cannot act really as the sole determinant of the outcome. In legal instruments, there are different understandings of cultural conceptions of the sacred, and they're all lumped together. So legal instruments hardly ever uses this word. And they lump it under umbrella terms of cultural heritage or of national heritage and so forth. But these understandings ultimately affect how cases are dealt with. They promote clashing outcomes, partly because of gaps in the conceptions of responsibility. So decontextualization drains this material of their meaning, yet the material must see its meaning fulfilled. The need to move to a more constructive or critical research in the context not only of human remains, but also artifactual human remains, animate and potent beings, grave goods, is quite urgent. The management of museum storage spaces deserves very special and dedicated attention. I think the Netherlands has seen the example for itself in the Rijksmuseum. We also need to be mindful that gaps in object documentation can be maybe expressed in ways that refines museum practice. And then we need to be super careful about what we mean when we throw around the word restitution. Do we mean physical return to the community of origin? Do we mean control over the data and justifiably extracted for research purposes? Do we mean access to and control over information about and images of cultural material on databases? Do we mean all of these? And what about the cultural heritage nowadays generated by AI itself? So let me introduce my core arguments. My first core argument is that the sacred supports a methodological innovation. I think the law needs it, although, one has to be supremely careful about how one presents this argument because it can be misinterpreted, misread. So law and ethics approaches can restore, I think, the capacity of the material. And by this material, I mean looted material, not just war booty, but any looted material, any trafficked material, any unethically removed material. So not just confined to war or hostility. And the material can challenge the stale discourses of the belonging and the ownership, I think. Art historians are very good with acknowledging that material has capacity, it has agency. So the sacred can direct our attention to a more holistic and integrated approach that helps set priorities. Obviously, indigenous peoples do not need the concept of the sacred, but the West needs it. The law in the West needs it to set priorities and to come up with some novel answers to questions of imprescriptibility and inalienability. But the success of restitutionary claims to sacred heritage also depends, I think, on a deeper understanding of this non-legal factor that drives the claims. At the core of the legal basis for claims to sacred material is their intangible heritage value, but the legal tools are simply not in place to meet these claims. Indigenous peoples already account for this value in their worldview. They are spurred to action by the equivalence of their sacred heritage to being human. Human to stand in for them, to be more than human. But in the West, the implications of the intangible are more difficult to grasp, especially in the absence of a common legal basis of claims relating to the colonial era. So the main challenge is to find and define intangible cultural heritage in a way that integrates it with the tangible, that cuts across social sciences and humanities, and that surmounts the dichotomous thinking. So, for instance, in the mummified monk, we know that he has intangible qualities that mark him out as sacred in the domains and the inventory under the 2003 UNESCO Convention, but perhaps harder to distill in the case of the frieze and of the power figures associated with voodoo religion. So what is the potential for common conceptions of the sacred? I think for several faith traditions, self-sacrifice or giving the self to the world is a model, that the world is given to us and we have the capacity to receive it may be palatable to many of these traditions. But Biannual, a Talmudic scholar who survived the Holocaust, maintained that existence doesn't really come to us as wealth to be received or accepted. Rather, being lacks a certain specificity, and for him it was akin to a horrible neutrality. Another common conception of the sacred derives from memetics or mimetic competition, mimetism, the imitative predisposition that fosters human desire. And the great proponent here is, all the anthropologists will know him, I guess, René Girard, a contemporary of Frantz Fanon, a historian and philosopher of social science, who theorized that imitation is the initial and the essential means of learning, and the conflict between rivals flow from the proverbial duel between the twins. So think of King Gezo and his brother, or of King Erechtheus and Poseidon's son, or the duel, the struggle, the hostility between Britain and France, for instance, in the late 1700s, early 1800s, the competition between them to extract the marbles from the Ottomans. So Girard's formulation represents one of the most encompassing, challenging, and far-reaching theories conceived in the humanities in the last century. He theorized that the drive to violence makes violence inescapable, except there's only one way to escape this, by awareness and understanding the laws that govern it. And according to him, the law that governs it is the expulsion of the outsider victim, who's then collectively persecuted, victimized, destroyed in a collective ritualistic sacrifice. Essentially, then, the collective envy and the hostility of society is projected onto the scapegoat, and this controls the aggression, channels the competitive urges and the uncontrolled violence, allowing human societies to manage their relationship with the sacred, allowing them to foster a certain solidarity. This makes peace possible, and this allows for societies to survive and to flourish. That the drive of the colonial powers to deploy violence, to have more than others, manifested in their narcissistic demands of cultural property and heritage from indigenous communities living on territory claimed by settlers. And one also sees the theory at work in contemporary discourses or in colonial mimicry, etc. Now, in historical prosecutions, the scapegoat conceals the genesis of the sacrificial stereotype. So humans are disinclined to acknowledge participation in this mimetic dynamic. Their disinclination, according to Girard, is directly correlated to the crisis of violence in the world. Think also of the public opinion at the time and the projection of savagery. They are the savages, not us. So that is how the dynamic plays out. So the need of so-called advanced cultures for the persecution mechanism remains masked, hidden. Ancient cultures, however, did not mask their participation in mimetics. For instance, the custom of human and animal sacrifice in Great Benin was never denied. It was never covered up. Arguably, all cultures participate in mimetic competition, even if the cloak is that we're doing it to bring an end to human sacrifice, or we're doing it to bring an end to slavery. So integration of these two, the mimetics and the sacred, offers a unifying point, I think, for social and human sciences. But without understanding how they're integrated, we are just left with might makes right. Whoever is the strongest puts forward the law that governs the situation, and the law becomes more indeterminate and more divided than ever. So force, duress, can acquire normative effect. So this brings me to my second core argument. I'm not going to drag it out. It involves the law, and it is about this propensity of normativity to go in one of two directions. The effects of the normative, or the normative effects of the phenomena associated with claims for return, draw attention to the sacred or to the status of gift in a theory of obligations that precede rights. So we very often fall into the trap of thinking that obligations are somehow the counterpart of rights, but in fact, there are obligations that have absolutely nothing to do with rights. And I'm thinking here not only of Levinas, but also Marcel Maus's compelling inquiry into the law, economics, and mentality of the gift. So he did a very profound, all-encompassing comparative study of Polynesian, Melanesian, American Northwestern, Indo-European, and ancient Roman laws in his essay, The Gift, in 1925. So Maus formulated a gift theory that encourages critical questions about the nature of gifts as reproducing social relationships. And when gifts are given as tokens of loyalty by groups or persons to colonial occupiers, these gifts act as representatives. They're representatives. So I can put forward only very brief observations for now, starting with national and international cultural heritage law and private international law. They contribute to the broad phenomenon of the normative, but the implications of their interface with colonial takings remain to be worked out in a much more systematic way. Private international law is the legal discipline that justifies the application or the non-application of other legal systems or rules, and it is concerned with secondary legal norms that condition the spatial and the temporal dimensions of primary legal norms. So it's more or less accepted today that the origins and the development of both public and private international law are connected, deeply connected to an imperialist and a colonial legacy. So the tools that they offer cannot be used in colonial settings without considerable sharpening for restitution claims. So I think my basic point here is that we have to acknowledge that it is necessary to restore the law. We cannot just work with it. We have to restore it, restoring it for restitution. The law has to be restored. And this implies the integration of liability, responsibility, and obligation. A common understanding of the sacred can start to support this work, I would propose. But scholars typically sideline the external and internal conflicts of law that occurred during the colonial era. The bypassing of the normative conflicts in the colonial undercurrents of law is a highly problematical aspect of legal research, and furthermore, private international law classification is as problematic as reactive provenance and collections research. Nonetheless, the law of restitution of cultural property and heritage cannot be restored solely at the level of primary legal norms. Secondary legal norms deserve acknowledgement. So now pulling all of these core arguments together with the ethics and law theme, I want to illustrate the use of private international law as a model of ethics that prompts a rethink of questions of restitution and belonging. So in the Parthenon marbles case, private international law highlights this classification of immovable and movable. Clearly, the fragments of complex temples become movable only after their unauthorized or wrongful removal. So there has to be a crime for the law to be able to categorize and then to come up with a certain result. The law of the place where fragments, friezes, and embedded sculptures were taken, clearly that law should apply. So how Britain can think that the British Parliamentary Committee can, indicate British law as the governing law for the marbles, that, just defies description. So the mummified monk sacrifice further draws out dimensions of responsibility and respect which individuals owe to one another and to the communities in which they operate. And this is a theme that's unpacked by a young private international scholar by the name of Biannual in her recent works. I think the Chinese cases highlight the salutary effects of applying the law of the place where the theft occurred, so Yangshun, where the Buddha mummy was taken from, and also the international public policy against illicit trafficking of culture in the Cultural Heritage and Property Conventions. So in conclusion, you will note that I haven't said anything about the power figures yet. Legal constructs fall away. They fall away when the security of a dispossessed society is threatened at its core. Non-restitution of the statue of the voodoo god of war, Gu, to Benin highlights the sacred and the normative and the axiomatic self-defining quality of this material that engenders normativity. So the external and internal dimensions of conflicts of law interlock with status, place, parameters of customs, beliefs, and practices in indigenous society. Also its structure and its organization at a very, very deep level. So when the Quai Branly holds 70,000 items from Africa, as does the British Museum, but we're talking about Quai Branly, then returning 26 items to Benin, I would say it is unpalatable, to put it very discreetly or more bluntly. It is a treachery. So I thank you for your kind attention.
Thank you. Good morning, everyone. I hope you're still holding on before the lunch break. I'm very happy to see you again because I think some of you heard me speaking about human remains a few months ago. So thank you for inviting me again. But this time I'll talk about something a bit different because I was actually really interested about the topic of the conference today because it's questions I'm currently thinking about, and both of your talks are quite related to what I'm going to say, so there might be some repetition. Apologies for this, or another way of putting it anyway, and I also see things to discuss afterwards among the three of us. So just to start, but I already said it a bit last time too, when we talk about in Dutch, it's not very easy to translate, neither in French nor in English. When we say roofkunst, actually it is both for illegal acquisition of art and illegitimate acquisition of art. It goes for both of them. So it's an encompassing term, which is interesting because it's actually at the interstice between both of them that we can do something. Was it illegal or illegitimate? Well, it was both roofkunst, which is broader than just looted or war booty. And so very often there are distinctions in international or national law, whether it was stolen or taken in the colonial context or in a war context. Second World War, you have a lot that's been already researched on this, or illicit trafficking. That are typically the three aspects. They are not very often linked, but I think they could be more. But that's often how we got interested into these questions. And now, the idea is that if you have an object that has been taken, roofkunst, illegally or illegitimately, it can open claims. It can open a claim for restitution, or it can open like a broader claim for return, where you don't have this idea of restitution, of repairing a past wrong, but more like giving it back, returning, transferring property, depends, right? If you use one term or the other, it also shows if you're just redressing a historical injustice, or if you just focused on a diplomatic win-win exchange and you just give it back. So, the issue of legality or illegitimacy is really very important because it will determine whether you stand a chance for a judicial claim. If the object was taken illegally, if it was illegal, you can go in front of a judge and claim it has been taken illegally, it was stolen, or it was taken away without any export license, so I need to have it back. And if you can prove it, and if you follow all the quite heavy steps of a legal procedure, you can have it restituted by a judge. So that can be a very easy way of obtaining restitution, and it happens quite often. It happens a lot for illicit trafficking. It happens also for Second World War spoliations. I'll get back to that, where you can go in front of a judge and just make a claim for illegal. Okay, but first question, and it's a bit what already Wouter and Christa said, is, okay, but illegal according to which laws? According to the violation of which laws? Well, normally the answer would be, well, it's illegal because you violated the law at the time of the acquisition. When you acquired the object, you violated criminal law that said it was theft, or you violated international law that said it's not allowed war booty, or you violated civil law because you took something that you thought was your own but it wasn't, or whatever. So you look at the law of the time to see if it's illegal or not. And that's typically the idea of the intertemporality of the law, which was already mentioned a bit this morning. It's a quite famous principle, and we often refer to an old arbitrary case that concerned actually colonial takings of land. It was a dispute between the Netherlands and the United States of America, the Island of Palmas case in the 1929. And then I just take out one small passage. It's also quite interesting to see, can you just claim territory that's supposed to be uncivilized, but that's another discussion. And here the judge says, the idea is that a juridical fact must be appreciated in the light of the law contemporary with it. And it makes sense, because when you act in a certain way, you act because you know that you can do it or you cannot do it. If later on what you did was not allowed, well, you could not have predicted that because he didn't know how the law would change. So there's, of course, some certain logic to make sure that you apply the law at the moment of the facts. So if at a time you take something and it's not considered a theft, but it's considered a theft later on, well, you couldn't know it was a theft then because it was not criminalized. So that's a bit the core of the idea. It's to make sure that when you act according to legislation, well, you know that you're doing right. So that's why it's interpreted this way. But that principle is not considered absolute. It's a strong principle, but you have exceptions to it. You have sometimes what we call retroactivity of the law, where the law applies to old facts that happened before that the new law came. And so that you have some kind of retroaction from legislation. That's something that happens. And here it's also something interesting. I think I already mentioned it last time, so sorry for those who hear it again. But it's a case not in colonial takings, it's a case of illicit trafficking. Maybe you know it, it's the statue of victorious youth that is in Malibu in the Getty Museum and was bought by the Getty in the 1970s in Germany. But it was found, that statue, in Italian or international, it's not very clear, but in the waters in the 60s by fishermen who brought it to Italy. And it was smuggled out of Italy and it happened to be found back in Germany, and then a German art dealer sold it to the Getty Museum. Ever since that the Getty bought it, Italy has tried to ask restitution. It asked through diplomatic means, it tried judicial means, and at the end, having expired all judicial means, the last Italian court decision of 2018 said now it is Italian heritage. It should have left. It should not have left Italy. There was an export ban because it's part of Italian heritage. So the Getty should not have taken it. There's a problem with the provenance of the statue, plus the Getty knew it when the statue was bought. It knew that the provenance was a bit dubious. So actually, Italy should give it back. Oh, sorry, the Getty should give it back to Italy, sorry. But the Getty was, of course, quite annoyed with that decision, so it decided to go before the European Court of Human Rights to make sure that it's the owner of the statue and to end the dispute. But unfortunately, the court did not really follow the argument of the Getty and recognized that Italy had a legitimate claim to ask restitution. And also the court said that today there's an international consensus on restitution of stolen and illegally exported art, which is also actually quite interesting that this court explicitly notes this right to restitution. But more interestingly for today, one of the passages of the court decision says, well, actually, back in the time, in the 70s, at the time of acquisition, there were no international conventions that forced the Getty to ask for an export license, or there were no international conventions that were very clear on the diligence that the Getty should have taken when it bought the statue. So if you apply the principle of intertemporality of the law, well, the Getty was in no obligation to make a very strong due diligence or to think about export licenses, so it was all good back then, right? But there the court changes its mind and says, and I will quote, so the domestic authorities in the present case, so Italy, operated indeed in a legal vacuum. There was no international conventions, and you could see the parallel also with the colonial times, right? Where there was also not really specific conventions, as none of the international instruments which would have helped them to recover an unlawfully exported cultural object were in force at the time, so the 1970s. By contrast, the court stresses that nowadays, in a similar scenario, so where the statue found today in Italian waters and taken out of Italy to Germany without any export license and then sold to the Getty, the domestic authorities, so Italy, would be under a duty to strictly comply with the time limits and procedures laid down, and then it sums up like the actual conventions, the UNIDROIT Convention, and also a European directive. And the court decides that that legal vacuum from that time cannot be held against Italy. You cannot reproach to Italy that it could not ask restitution at a time because there was a legal vacuum, because it incessantly asked restitution. It always acted for restitution, and of course it didn't have international conventions like it could have today, but that cannot be held against her. So it's interesting because it's some kind of a break in this idea of intertemporality. It's somehow saying that if you look at the law today, well, today you have a lot of standards that would imply that the Getty didn't do its due diligence. And that's also the way that the court will decide. So that's a first remark of this idea of the illegality, illegal violations according to which laws? Well, the laws at the time of the acquisition, but there might be a little bit opening there. But the second remark is more important and also relates to the two speeches before me. It's the idea that it's the presumption that in the colonial context, a lot that happened then was legal. But was it? I mean, the argument of legality itself can be put into question for a lot of reasons. And then I'd like to refer to a PhD student, Maxime Smets, who is exactly doing his PhD on that topic, about the legality of international law at a time on colonial takings. And you can make a strong claim that international law, a bit what we heard just before me, that international law itself is biased, has a colonial paradox, like he says. There's a form of hypocrisy in international law to favor, of course, certain takings of land, of objects, and cover it up with international rules. So that, I think, is a strong stance, a critical stance. You could also say it's a more decolonial approach, even though that word is sometimes used as a buzzword. But anyway, it's interesting to have more this critical approach on the law itself. It's not like one block, okay, it was legal at the time and not going any further. I think it's supposed to be more critical. You have also the current, which is called TWAIL, so it's third world approach to international law, which is also quite critical about international law at the time of colonization. And if you can make all these claims, well, then you can say that actually the takings were illegal at the time, because the legality that was used is in itself problematic. So that's the first claim you can make, and then you could go further into this. Okay, but that's one scenario, if it's illegal violation of laws at a time, but which laws, and can you not put those laws into question? Second approach is to say, but it might have been legal, we don't know, maybe, probably, but there's a problem with the legitimacy today. It's illegitimate. And so there you don't have a strong stance before a judge, because if you just say, well, yes, the museum is now the legal owner of the objects, but I have been robbed so many years ago and it's unjust, well, there's a high chance that the judge won't listen to you because you don't have a strong legal claim. So you go outside of courts and tribunals and you'd rather look like a political approach, a policy document like in the Netherlands, or like the Sarr-Savoy report, but Sarr-Savoy is indeed a bit also going into law, but you rather, you go into the ethical dimension. And so you recognize there is not a legal duty to give it back, but a moral duty to give it back. And that's also what inspired the Belgian law, which I will go back to in a second, that you need to repair past injustices, and to repair those past injustices, you think about restitution, but the decision remains the decision of the actual owner. He's never forced by a judge to give it back, so it's a bit different. But there's also, of course, the framework and the idea to work on ethical dimensions. So this brings me actually to the matter I wanted to share with you. It's the Belgian law. So we have a law, which is very interesting, a general framework for colonial collections in federal museums, so only publicly owned collections. And in the law, there is this idea that there should be bilateral agreements between Belgium and Congo, between Belgium and Rwanda, and between Belgium and Burundi, the three former colonized territories by Belgium. And in this bilateral agreement, one thing should be certainly included, is that there should be an advice by a scientific committee on the restituability of the goods. And that advice on the restituability is based on one criteria: it's the illegitimate acquisition. So in Dutch, it's a bit weird, and Wouter already had a critical stance on this. In Dutch, it's called onrechtmatig karakter. But actually, I think it's a wrong translation from the French, because in French is acquisition illégitime. So we're clearly into the ethical dimension. I know that onrechtmatig can refer to civil liability in Dutch, but that's not the idea. The idea is really to think about the illegitimate acquisition. Okay, so that's the criteria. You restitute if you can see that the object has been illegitimately acquired. But what does that mean, illegitimately acquired? You know, if you are in that commission and the idea is that there would be half experts from Belgium, half experts from the other country, you sit together and you should think about, okay, have these objects been illegitimately acquired or not? So the legislator obviously wants you to go back in time, wants you to think about what happened then at the moment of acquisition. It's not just seeing what would be the best solution without having to look up about what happened during the acquisition. So you need to go to this acquisition idea. And you should think, was it illegitimate? Well, there is not really a lot of criteria that are given by the legislator, two of them, which I highlighted. And it's the matter of duress, dwang, la contrainte, or gewelddadige omstandigheden, violence, la violence. So it's a bit force and duress you talked about just before. So these are two indications, because it's inter alia, if you want, that the law says. Two indications, it's if it has been acquired under duress or under violence, which is, by the way, two arguments to consider it has been illegally acquired and not illegitimately acquired. But anyway, so that's where it all started for me. And I started to think, okay, but how do you move on, actually? How do you, if you need to think about all these objects in the federal collections and you have this criteria of illegitimate acquisition, you have this idea of force and duress, duress and violence, how do you work? You know, and there I mean, and it's really a question, I don't really have the answer. I will give you some ideas I have, a hypothesis, but it's still not very clear in my mind. But what is really clear is that there is an interaction between the legal and the legitimate. It's quite clear that illegitimate goes beyond illegal. It's more, it's broader. But how far it goes, it's not very clear, which is fine, but it's interesting. And so if you look at other contexts of restitution, which I think is interesting, the Nazi-looted art restitution, you see that those questions have already been raised in other contexts. And that this idea to play between legal and ethical, well, it's also very present in Nazi-looted restitutions. 10 minutes, okay. And so I already referred a few times, and I reread it in the train to be really sure. And I refer to her again because it's quite enlightening. You probably know her, Tabitha Oost, who compared how you go from a more legal approach to a more moralistic approach, victim-oriented approach, where you insist on the emotional link also between the victims and the object. And how the commissions that she studied the Dutch Restitution Commission and the UK Commission on Spoliated Art, how they also balanced, how there was a constant tension actually between those approaches. And a bit what we heard this morning too, like the plea of Wouter to combine law and ethics. It's also something that happened in Nazi restituted art. Again, in the train, I reread the French law of 2022 that agreed for the restitution of 14 art objects to Jewish families. And one of these restitution is purely based on a legitimate consideration. It's stated like that. The two others, there's clearly an illegal aspect to it. There was a theft, there was spoliation that was very clear. But in the second case, it was not very clear. The sale was actually quite legal, but it was considered unethical. And therefore, there is a decision for restitution. So you see that they also try to have like both approaches working. I don't know exactly how it worked out. It was not really clear. There's a commission also in France to take that into consideration. But so you have these both approaches. The advantage of a more legal approach is that it's more predictable. You have clear criteria. You know if you can, you never know for sure, of course, because there's also always an interpretation, but you have a quite predictable framework. It's also the advantages that Wouter highlighted. A moral approach might do better justice, might better take into consideration the status of the victims, but it might also be a little bit more arbitrary because it's more based on what's considered just for this particular case. And you might have decisions that vary between cases. And so you might create, without necessarily wanting it, inequalities between claims and restitutions. There's also an interesting paper on the difference, but I don't have time for this, on the difference between provenance and origin. I think that's interesting, maybe more like a legal way of thinking. Very often in the law, you have this idea that you give back to the country of origin. But what is the origin, right? What is it? What is the country of origin? If it's an archaeological object from the ground, maybe you can easily find it. But if an art object that traveled through or that comes from a state that happened to exist after that the community made it, can it still be considered the origin? Whereas the provenance research is a much more dynamic view that's tracing all the history of the object. But it's interesting also to take that into consideration. And so I try to think further and to say, well, if you have this illegitimate acquisition, could you have like a gradual approach? Would that work actually? And is it something to go forward with, to have the best criteria possible and to have like a grid to see how acquisition would be illegal, illegitimate, legal, legitimate, and how you can move on for restitution decisions. To make that grid, I think it's important to have a pluralist methodology. We already heard that also this morning. It's the idea that you don't just consider what's legal or illegal according to one point of view. That would be like international law and colonial law, but you also take into consideration other legal systems that were equally valid at the time. From local law, for instance, that can be written or oral, but that can also have equal effect. I think that's also important when you take the legal argument into consideration. And then, of course, you remain critical, like I said before. It's more this decolonial approach, this critical stance on even though you can claim that this was legal according to the grid, you still need to have a special look at it and to understand the context behind it. And so we get to this. This would be the idea. It's in construction. It's not perfect. So it would be to cross the legitimate approach, ethical approach, with the legal approach. And it's the first time I show it, so I'm not very sure. So the idea, I will start from the bottom. For instance, the one that the Sarsavoir report starts with, the war booty, would be, for me, dark red, in the sense that it's considered illegal according to international law at the time, and it's considered illegitimate. So if you have such a case, the restitution is a no-brainer, right? I would say. Then you could have, but there are, of course, many other possibilities, but it's just some ideas I had. Then you could have the case of theft, a theft that happened according to colonial law or according even to national law. I was just reading right now a very interesting case on that was decided a few days ago on the Métis. Maybe you heard about it. The 5 Métis women that asked for reparations because of the deportation they had. Well, the judges recognized it was a crime against humanity, also looking at national Belgian law at the time that forbade to to take away children if they were not orphanages. And they didn't look at colonial law, they looked to national Belgian law in Belgium, but even though it was applied in the colonies. So I think that made me think of an extra argument to say maybe it was theft according to metropolitan law. Anyway, so that could be also considered illegal and illegitimate. Another category could be like scientific collecting. Very often it's covered by some kind of legal framework, but it could be contrary to historical customary standards. For instance, I was in Antwerp a few months ago, and I heard Professor Diboy saying that at the time there was a prohibition in certain communities to offer fetishes. So for me, that's a legal stance. From another perspective, it was forbidden. So if you have it in your collections and you say it's a gift, well, actually, according to the other, it was illegal. And then you go into the more yellow zone, legal scientific collecting, but contrary to colonial historical standards, if you can find examples. And then you move on slowly more to the zone where it's between illegitimate and legitimate, but into the legal already, where it's legal scientific collecting under the law of the time, but contrary to current standards, where, okay, it was legal back then, but it's considered illegitimate in the way it was done according to today, and you still are in the illegitimate acquisition. Then you move on to the gift, but of course the idea of the gift can also be put into question, like I heard just before, so that, again, you should put that into perspective. Was it a real gift or not? Or the idea of the commercial exchange, well, that was legal at the time and it could be considered legitimate. So that would be the idea. There are, of course, shortcomings. I think I passed my time, sorry. There are objects where you don't know the provenance about. Sarah van Beurden wrote extensively about this. There are objects, 1/4 of the collections of the Africa Museum in Belgium, we don't really know the provenance, so what to do with them. There's the big issue of the burden of proof. I think there's not enough attention given to that. Who needs to prove what when you ask for restitution? I think that's also important. And the broader idea of what is actually really bringing justice. Is this grid really helping it forward or not? I think it's also important to put that into perspective and to think maybe to other criteria of restitution, not necessarily the acquisition criteria, but other ideas and, well, to move on. And just to finish, this idea, actually, I developed it in a research project, and I got the news 2 days ago that I received funding. So I'm sorry to self-promote, but there will very probably be 2 openings for a PhD and a postdoc, together with my colleague Bérangère Piret, who works in the National Archives, because there's a lot of archival work to be done there, to actually test the hypothesis I shared with you. Well, thank you for your attention.
Can I invite the 2 speakers, other speakers, to take a seat? Thanks a lot. I'm applying for one of those PhDs if possible. And there are many things that we could think about. I kind of wondered as we happened, how does one think of gift under colonial duress? What does it mean when I have to give? If the Maroons have an idea of common property, is it possible for one person to give it if it was common in the first place? Would that be legal? What happens when archaeology gives one an imperial right to occupy a place and take? How do we think about that? The question, which I thought was beautiful, the reclaiming of the sacred. And I think that's a lovely idea of what does it mean even to reclaim, because one of the things I think that happens in our museums as well is that we abstract, we separate what the sacred is from the object in certain sense. So what does it mean to reclaim the sacred? This is the moment for your questions, however. I have 16 million of them right here, but it is not for me to ask. Who has the first question, comment? And there's a mic that's going to circulate. Jos. Jos is one of our critical friends in the project. Yes.
Thank you very much for your contributions. Quite interesting. I would like to go to Marie-Sophie, your pluralist approach, and then to the third part, to the local law. And what has always surprised me is that if we discuss legal aspects, it's always about European or international law, which is European-made usually, and which is the law of the oppressor. And it's very little about the law of the oppressed. And my question, it's a very simple question. You know, what is the volume of knowledge which is available about local laws in the whole discussion? And it's a question to all three of you.
Who wants to start? And yes, go ahead.
Yeah, it's the core question. I think it's very important. So for the project that I just presented, we will focus on situation in Congo, and we have in mind that there will be 2 research stays in 2 parts of Congo. We're together with a team also of professors from Congo, and to get to know better what were the local laws at the time. Most of them in Congo, I don't know for other countries, are oral. Not a lot of them are written. So, but that doesn't mean that there's no knowledge. There's a lot of knowledge actually still going on about what was allowed or according to the local tradition. So that's one. And second, you could also go, and that would be for the PhD or postdoc in history, to look into historical judicial decisions. And in those judicial decisions, sometimes the judge refers to customary law. You also had sometimes dual systems. And that could be, methodologically speaking, 2 ways of getting to know better those local laws.
All right. Can we get answers first, Jos? We can come back, yeah? Who else?
Yes, I think very important question. And normally, indeed, the law at the time is understood as the colonial legal systems at the time. For example, the Las Palmas case mentioned by Marie-Sophie was about the question whether the island of Las Palmas belonged, according to colonial legal ideas, to the United States or to the Netherlands. But it is a completely colonial court case, which is very ironic because it is about the intertemporality of laws. But the presumption of the whole case was that the only thing that you should look at and you need to look at is the colonial laws of the colonizing powers and nothing else. So that is, there are some critical comments on this case in this direction, but not that much. But your question, I think, more to the point of pressing matter and beyond pressing matter. When I was in Sri Lanka a few weeks ago, it was about a project in which I collaborate with the University of Colombo and Professor Nazima Kamadine, who is also a critical friend of pressing matter. And this project is called Whose Laws? And this is the key question of the project. So what happened in the Dutch colonial period in Sri Lanka was where the taking of objects legal according to whose laws? So, and the idea of the project is to include the Kenyan legal ideas in this evaluation and see whether, for example, ideas of guardianship which were present with regards to, for example, the royal artifacts will shed a different light on this question of legalities. So I think we are moving now in a direction in which we will pay much more attention to the law at the time from the perspectives of the colonized or would-be colonized.
You wanted to fine-tune the question, was that it? You seem like you wanted to.
Well, yeah, it's very hard. It reminds me first of the history in the development of provenance research. Then we started with our own sources, and that was holy. And only later on we learned to listen to the other side. Now I see a similar development, but it's at a very initial stage. And if you allow me, I want to quote one thing from your own dissertation, Wouter. Yeah, I've also been in a train.
Yeah, he forgot it.
But somewhere you write that in 1944, the Dutch government in exile, they issued regulations declaring Nazi German laws null and void in case they were very oppressive, etc., etc. And my question again is, what about if countries of origin say, we declare all these laws null and void, and it was all stolen.
My presentation of today goes a bit in that direction. As I say, it is important to explicitly declare null and void certain colonial legalities, which enabled the looting, for example, the violent lootings in this warlike situation. So that would be, for me, a very important step that is yet to take. So I do not agree completely with the model of Marie-Sophie, because her red square is still utopian. Because, not, for example, the UK does not recognize, still believes in the legality of the taking of Benin in 1997. This is still green for them. So
all right.
there is
Okay.
still a
Okay.
will
Okay.
to-
All right. You kind of come back on Krista. Krista, do you want to say anything, or is it fine? You don't need to. Yes.
I'm not
quickly.
talking about Scotland.
Yeah.
Yeah, we're not talking Scotland at all. Present company excluded. I did want to say about the first aspect of yours question. What comes to my mind is the South African and the African, I think, reality that many customary laws were oral traditions, and they were written up by missionaries and colonizers, so they were contaminated. And so for that reason, the customary law, the indigenous law, is discounted by independent states. It can't be trusted. So there is the real issue for researchers. How do you access the real law? That's all I wanted to say.
All right. I want to recall, and might be bad memory, but yours, you might want to look. There is a book edited by John Komarov, where he goes into the question of the legal, looking at how customary laws also help to shape how we understand the question of the law. But that's a book I read some time ago, so it might be useful. Any other question? Because I have a burning one. Birgit, I would love you to go, but there's a question closer. Yes.
Thank you. It's a short one, I think. It's just a follow-up on the previous question. So what I've heard is there's a recognition of international law being rooted in colonialism and colonial thinking. So could we say, or if you reflect and look into the future, is there a move towards decentering this law, or decolonizing maybe this law, or moving away from looking at legality entirely in these discussions of restitution? What are your views?
Let me elect Marie-Sophie to answer that. Is that all right?
Thank you. So the idea of decolonizing the actual law, I have one example in mind because I just quoted it because it's quite striking. It's the affair on the Métis case of these women, because it's, for me, a good example. In the first instance, the judge refused to recognize that those 5 women who were deported from so it's the practice that children whose mother was Congolese and whose father was Belgian were taken away forcibly from their mother, put into an orphanage held by sisters because they should be civilized. So that was the idea. And those women said that these deportations, who happened systematically, were a crime against humanity between 48 and 61. And in first instance, the judge said, even though it's very terrible, historical injustice, blah, 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 you cannot apply the Treaty of Nuremberg that recognizes crimes against humanity in the Second World War context of war against the Nazi regime, cannot be applied to colonial occupation. So, voilà, that was the first instance 2 or 3 years ago. And now, just a few days ago, the judge completely reversed this and said that that has nothing to do with it, and that the Treaty of Nuremberg recognizes something that was more generally recognized, and so you can completely apply crimes against humanity in that case. And he recognized that these women were victims of persecution and crimes against humanity, and they have they receive an indemnity from 50,000 euros plus a lot of interest, so I think it amounts to 1 million euros. So that's, I think, a good example where you go way back in time, but you have like a more brave interpretation of international criminal law. But yeah.
All right, Birgit? Merv, is that okay, or you want Merv, or should we go further? All right, great. Birgit?
Yeah, I find it a very intriguing panel. Of course, the question posed is ethical or legal, and I think our two people in law, legal scholars, say no. You really have to put both together. And I read you, Wouter, and Anne-Christine, to negotiate in a way the relation between this pair. But then we have Christa here, who is not a legal scholar, I think, but art historian, right? And she makes a totally different, puzzling intervention. And I really have a question about that. And I want perhaps the legal scholars to talk about that. Because Christa said, the sacred can direct our attention to new legal thinking, and the sacred is in a way not needed by indigenous people, but we need it as secular moderns. I think it's a major statement, and of course you developed it, Girard and so on, all very interesting. I have lots of questions about that to you as well, but my question goes in a way to our two legal scholars. What do you think of bringing in this third dimension? What could the sacred do? Would you accept what Christa has argued, or would you say, no, it's fine, we stick with the legal and the ethical, we will be fine? Or does the triangle make sense? That's for me a really burning question, also as a scholar of religion, of course.
Yeah. No, one of you, Wouter. Yeah.
I was afraid that this question would come. I hoped not. But I also was a bit puzzled by Christa's intervention, but I don't think in my presentation I spent a lot of time to explain this relationship between the exile of the king and the exile of the objects, but also to highlight the sacred aura of these objects, because the objects are much more meaningful than their being objects, let's imagine. It is much more. It is they are sacred objects in a way. So, and they always speak to us, I think. So you can keep them locked up for a long time, but this sacred identity or this aura around these objects remain. That I believe in that. But legally, I also said at some point in my presentation that is in contradiction that we should not burden the objects with the responsibility of their own restitution. So I have difficulties with restitutions that are organized around the meaning of a particular object, because I think that is tokenism, because that means that each and every object has their own obligation to show how sacred and important he or she or them is in order to be able to be restituted. And that is asking too much of these wonderful objects. So we should be more respectful to the objects and organize their return without burdening themselves too much with their own restitution. And that also is important because that enables, on the receiving end, it gives much more space for the people who receive the objects to talk about their meaning. We should not burden the debate, the restitutionary work that only starts with their restitution, with their transfer, with all kind of evaluation of their meaning and their sacredness. So that is, but I agree on the importance of knowing how that these are sacred objects. So that I completely agree. And also I like what Christa said about that the law needs to be restored. But that's a different matter.
Can I give Christa the last word on this, and we could talk to Marie-Sophie later. Do you want to say something on this, Christa, please?
Yeah, I think the meaning of those objects is axiomatic. It's a shame that we feel the need to start to unpack and explain it. It's axiomatic for those cultures to whom they belong and where they are from. The meaning is axiomatic, it's self-explanatory, and it becomes circular. So where you see it is in the law that puts the burden of proof and the decision of standing to sue on the claimant. That's ridiculous. It is the possessor who should prove that they have legitimate and lawful possession. That's so clear from the sacred and from that paradigm. So yeah, I think it's self-explanatory in a way, but it's difficult to explain.
Yeah.
It's difficult to explain.
I'm going to do one little thing. I think I see a little group of conversation over lunch now, but I'm going to do one little thing as a push for one of our PhD students who is asking a similar question actually, because Stacey Marie, who is there, she questions the part of the restitution policy which thinks through value, the value measurement. Yeah. What's that? Yes, okay. Yeah, so the balance of value, because she's saying that if one were to think about the balance of value, then one has to take into the idea of not only the agency of the objects, but the question of its sacredness. That must come in how one understands what value one ascribes to both the taking, but also to the return. So that is something that she's arguing. So I'm going to ask her to talk to you in the lunch as well. There's a question online, and what is that question online? I think Fashri is going to read it for us, and then we have one last question after this, which will be
please
mine.
allow me to read the question in the chat room. So the question from Stefan Morozowski.
Okay.
So is the concept of sovereignty part of this consideration? Are these items not the sovereign property of the countries of origin? Because understanding that question of origins are complex.
Perhaps we could ask Marie-Sophie, because you were the one who mentioned the question.
But, not very sure. Could you?
The question of sovereignty.
Yes. Yes, I see what you mean. So it's the sovereignty of the state to determine what's the real origin of the object. I guess that's the question. It's to the state sovereignly to decide if it will give it back to a community, to an individual, to a family, or would keep it publicly. Yes, of course I agree. It's one of the difficulties to the question, to who you give it back, to who do you restitute. Well, if you have two states coming into the discussion, if it's not like the American context or the Australian context, but you have two states, well, then you need, in my opinion, to respect the sovereignty of the other country. And so it can sovereignly decide about that. And just to add on this, on the question of origin, and to give you some piece with that also, so the idea to restore international private law. Belgian international private law has a specific article that in case of theft of cultural goods, the claimant can choose the law of the state of origin. And so it's one of the few recognitions where you can choose to apply not the law of the state where the object is, but the law of the state of the country of origin. But what's the country of origin? Well, yeah, it's to be determined.
I want to close the session and probably go back to Merv, your question and tie with our last question about Wouter's idea of irreparability. Because in a certain sense, David Scott suggests that we are all conscripted. We are conscripted to a particular kind of modern world today, which include the legal frameworks and the legal systems of which we are all a part. We all sign these conventions even if we don't want them because they help us to do something. We're all a part of ICOM even if we don't like it. And therefore, in a certain sense, to think about decolonization is not only to think about a return to a Jamaican law, but probably to think about how we are complexly entangled to rejig the entire legal framework and what that might look like. But David Scott suggests, Wouter, and he also works with Hannah Arendt, and the question of the Holocaust, a certain kind of irreparability because of the evil that colonialism has done and continues to do to those who've been colonized, that they have been so broken and continue to be broken in the framework of present-day laws of legal regimes, of visa regimes, of whatever. So it is an unending wounding. How do we take that, deal with that unending wounding when the legal parameters of the present continues that colonial wounding of the past? Your advocacy is for a legal solution. But when the law of the present continues the wounding, what is your suggestion that we do? Because I wouldn't suggest Marie-Sophie as being utopian. I'd suggest your belief in the law as being utopian. Trouble. Just a question.
Is it a question or is it just a remark?
Yeah, I'm wondering, I just wonder.
Yes, but that's a question about do you believe in the law or not? If you don't believe in law anymore, what more, I think it is still a very strong moral standard we can use. So the legal is a sort of crystallization of a sort of common morality that is still there. Perhaps it's bounded, it is broken, but by setting this, by making the red square of Marie-Sophie really red internationally, we have repaired something of this idea, which may give hope to future generations or to the young people who are debating on what the return of the Dahomey objects mean to them. So it is at least a sign that things can change. So that connects a bit to your introductory remark, which was a bit more optimistic than this last one.
After your talks, the 3 talks, I've lost my optimism, and I think we should now go to lunch. Thank you all. Thanks for the wonderful presentation.